Mark Nation on behalf of the appellants. I'm going to address just the 4 issues on this proposal for settlement. I'll go through. Obviously, welcome any questions. Issue number 1 is the indemnification issue. The proposal for settlement itself had a requirement that my clients indemnify each other. There were 2 proposals for settlement, each of them for $501. Each of them required if they offered was accepted, to indemnify against any other person with an insurable interest in the money. That's in the proposal itself. The release said that they were agreeing to hold harmless and indemnify all claims a third party alleges a right, where a third party alleges a right to the money paid. Both of those required, if one of them accepted it, to indemnify for the continuing claim of the other insured. They try to make a distinction between the proposal and the release. 2 problems with that. One, it would make it more ambiguous if those 2 conflict. But the release itself would require if Mrs. Hartman accepted, and then Mr. Hartman continued along in litigation, and they have a claim to each other's money, because the only money paid under the breach of contract count for the house would be to repair the house. They both have equal rights to that money. Yes,
I understand your argument, and I get how you're constructing it and all that. It's really hard for me to get past the pragmatics of this, which is, in what conceivable set of circumstances could you have it where husband and wife own the same property, it's the same claim, it's the same underlying event, it's the same, it's a one unified policy. It's going to be one payment on it. In what universe could you have it where one's going to accept and the other isn't?
but we have that. That happens.
Yeah.
That does. Oh yeah, absolutely.
But in a divorce,
Oh no, that is a situation where it is, but sometimes one of them takes it, and because the amount we get to the good faith issue in a minute, the amount of money, the one will take it and say yes, but there's no indemnification. They're allowed to do that in that circumstance. But here, they've got these non-monetary terms, which is obviously another issue, that prohibits it. They can't independently do that. Now
they can. It's just, it's not like the situation where it's an all for one for all,
joint
offer, or even individual offers where you're saying this is going to be subject to the other side. So it's not that they can't do it, it's just what you're saying, it's a bad deal.
No, they won't. They have no idea what they're signing up for.
A bad deal.
Yeah, well then, it would be bad if that's
But
the
there's nothing
point.
in the terms of the offer that prohibits them from accepting independent of the other.
No, it's the case law that tells us that they have to be able to independently address those. Safe Point versus Brown.
Assuming there's no marital problem, and then you're telling me that like this happens like on a singular claim, singular property, where they're both the named insurers. One takes the money and the other says now.
And they'll make a reasonable offer with no indemnification language? Sure. Yeah. And they do those exclusive and non-exclusive, so you have fees and costs, and so you have various scenarios. But the indemnification is the problem here. On issue 1, they shouldn't be required to indemnify each other. They should be able to get out of the litigation.
Well, then that kind of segues to the next one. I'm sorry to jump right in.
Please, you're not, please. It's better this way.
Indemnification per se isn't a problem, at least according to the 4th and 3rd DC case, right? Because the Kush case says you can structure an offer in OJ so that one offeree has to indemnify the offeror for a claim against the offeror on the proceeds of the offer. The Safe Point versus Brown case out of the 3rd DCA. It's a water intrusion case that involved indemnity as to proceeds.
So Krusch only talks about ambiguity. That's it. And I agree. Including that doesn't make it ambiguous. It's clear. You're going to indemnify it. So the issue is you can't do the independent evaluation. And that argument was not made in Kush. Kush didn't talk about, it was only ambiguity, and that's all they dealt with. And then they start talking about punitive damages. and this issue isn't raised. Because sometimes you can make a proposal super clear. It's still invalid.
I mean, I get what you're saying, that the issue doesn't appear to have been, I mean, we don't know if it was raised or not. Maybe it was raised, they just said that's silly, we're not gonna.
I don't think it was made. I mean, nothing even
We
indicates.
don't know, we can't, we're not supposed to straight down the four corners of the opinion, but my problem is it is out there. Certainly, it seems difficult to conceive that if indemnity was just per se beyond the pale in an offer of judgment, like you just can't do it. Seems like that would be such an important point, that someone would have held that back.
Somebody has, the Supreme Court in their amendments in 2022. Because of what we're doing here today and having done it so many times. What they said is we were going to bring our rule into alignment. And let's think about what that means. With the statute, what they're saying is, hey, like all of us, we made a mistake with the rule. The rule's too broad. What we want is an evaluation of monetary terms, and that's it. Let's look at the amount offered and the amount of the judgment, which makes it easier, and we're not doing this all the time. And so there is a way to do it. Just do that. The statute says it is an offer or demand for judgment. That's it. So if you're going to make an offer of a judgment, do it.
So you think that wipes the slate clean as to the bad faith aspect? You no longer include bad faith claims as part of an OJ?
They can include it, but it's invalid. It's extrinsic.
Okay, so I appreciate the candor. Your view then is that amendment indicates a clean sweep of all the case law before the bad faith claims, indemnity, all that.
It absolutely is telling us, here's what the statute is. We're going to bring our rule into alignment of that, and that is so that we will have only a comparison of the monetary terms, and that's it. And I think it's very smart to do that. So you offer a judgment. Here's your judgment, just like you went to trial in this case. Your judgment is for X number of dollars. And that's why it's saying offer of judgment or demand for judgment. And then that's your judgment. Well, what could have been resolved in that case? We do know that if you go to get a judgment in a first party case, in your breach of contract act, if you win, you can then file a bad faith case. Barton tells us that if you resolve it with a proposal for settlement, you can also then file your bad faith case. I get that they would want to include that in a proposal for settlement. It's simply not valid. And it probably works in a number of cases where they make an offer, it's everything, somebody takes it, it's done. But that's not where we are now. Where we are now is it valid? And I don't think under the bringing it into alignment, it's valid. And if the court were to affirm this, then that just continues this trend requiring this. We have a clean slate. The Supreme Court is saying we're bringing it into alignment. The rule, the statute has never allowed it. So next is the extrinsic claims, and that's what I was going to argue on that. And only compare monetary terms. They say it in the opinion. That's a quote. That's it. That's all we should be doing. It's a math problem at that point, not checking and seeing if we're lying under oath. That's the next one. Is there a lie? Was this negotiated? This was not negotiated. Take it or leave it. You're required to sign this release, and then it says, we've negotiated this. That is not true. Final issue is the good faith issue. In the record, and I would encourage the court, on page 674 of our record, I filed a motion for rehearing. And that's the hearing on the motion for rehearing. Put into the record and told the court, I am telling the court on this good faith analysis on liability, the exact issue for which summary judgment was granted in this case. I have tried to verdict many times, and I have won summary judgment on this multiple times, and I have never lost it. This still remains the only case I've ever lost this issue on summary judgment. Therefore, in the analysis is, you got to look at the entire record on the good faith analysis. And I want to make a point. we're not saying, when we say good faith and bad faith, I want to be clear. The offer of the judgment has to be a good faith effort to resolve the case. It's not a prevailing party issue. Good faith offer to resolve the case. That's what it's got to be. And in looking at that, there are two issues that you look at, and you have to review the entire record to address these two issues. A reasonable relationship to the claim damages. No, not even close. They didn't even try. $120,000 estimates, it's the only evidence in the case.
Right, but I mean, you got to compare it to what the policy covers.
Oh, it covers it. That's why I mean, this is the only time I ever lost this.
This was the case where the water intrusion never actually did anything inside the house. There's no damage to the car, it's just to the underlying, to the fill.
The structural fill, which is, I get jury instructions, I put this in the record. I get, when that issue, structural damage to the structural fill all the time at trial, summary judgments on it, I put them in the record. I get jury instructions, say structural fill is part of the dwelling. We've got multiple cases where that's happened. And so that issue, that goes to the second issue, which is a realistic assessment of liability. So if we're going to do a realistic assessment of liability, it isn't just, well, did you win? Because that's kind of where we are. Or did you lose? It's not that. Look at the entire record. And the only evidence in this record is that I've tried that issue multiple times, never lost it on summary judgment once, and this is the only time. And so we look at that $501 with some skepticism. The case law tells us you gotta look at it with skepticism. Look at the entire record. Is it good faith? What is the only evidence in this record? They didn't address the damages component. The second component is a realistic assessment of liability. And all they put in is, well, we won. They don't look at all the other evidence. And I can't, and think about this, how do I go to my client when I tell them, I've won this issue all the time, try it all the time and won. I think I've tried 30 of them, but we should settle for $501 in this one because we might lose. Not the purpose of the proposal for settlement. Back to a good faith effort to resolve.
I'm not sure your notion of good faith jives with what the case law is saying, which is to say we should look at a lawyer's track record on other claims in other places. I'm not sure that that's exactly what the good faith component of this is.
It's
because you can have a nominal offer.
100%.
And that'd be good faith.
And it can be, but it's always looked at with skepticism. And then you look at, here's what we're told, look at the entire record. Not part of it, the entire record. And what is in this case? I'm in a very difficult position in a case like this, where I continually won the issue and continue to, as I tried it last week and won it. And then we have...
Scott, you keep talking about what you've done in other cases.
Yes.
Is that in our record?
Yeah, yes, it is. On page 674 of the record, in the motion for rehearing, put an affidavit in, put the other words in.
Okay, all right, I just want to make sure.
Yeah, and I feel, look, I don't want to sit up here and say, I know how it sounds. But when you look at, you have to look at the entire record, then that is obviously a component of it. Because the lawyer, whoever the lawyer is, has to go to the client and say, all right, this is the issue, structural fill, whatever. Here's my record on it. Haven't lost it. They're offering $501 on your $120,000 claim. I can't tell you in good faith you ought to settle it for, because we might lose. So the past record has to be considered.
And again, I think you managed to flip the hats here. I think the good faith, it has to be, is it the insurer that's acting in good faith from their point of view, not the lawyer who's counseling the client. I've never seen a case that talks about it from the, because here's the thing. Presumably, if you're still in business and you're doing well, you've won a fair amount of cases. You've done good. That's great. But I don't think that's where the law is focusing on for purposes of good faith. I think it's looking at the insurer. Is this based upon a reasonable insurer's assessment of the potential risk and exposure of the claim? And that may be $1 or it may be, $100,000, but I think that should be the perspective, not you counseling a client.
So the definition is good faith effort to resolve the case. And so it's not talking about their
But
acts.
who's the one that's issuing the offer? It's the insurer.
Right, but we look at the entire record.
Right.
So the good faith effort, is it a good faith effort to resolve the case? It wasn't, they didn't address issue 1, they only addressed issue 2. And,
Sir, I
Yes,
just
sir.
want to let you know you're at 15 minutes.
okay. Let me see if there was anything.
You can use your time however you like.
That's all I have right now. Thank you.
Okay, all right.
Yep.
May it please the court. My name is Ryan Jones and I represent Tower Hill. We ask that the court affirm the trial court's decision to enforce Tower Hill's proposal for settlement. Doing so enforces the statute, it follows Florida Supreme Court decisions interpreting the statute, and it would be consistent with other decisions from this court. I'll highlight just 3 points, and in doing that, I'll be happy to answer any questions that the court may have. The first point that I want to address is with respect to the indemnification provision. What appellants are doing is analogizing to the provision in the Brown case. That provision specifically stated that there would be indemnification unless both plaintiffs accepted. So it essentially took away their ability to independently accept or reject. But that's not the same language that Tower Hill used in this case. Tower Hill's provision only requires indemnity if a third party makes a claim to the settlement proceeds. And I think that's very important, to the settlement proceeds. Because a
I'm
settlement,
not sure you can read it that way, I mean, and I'll tell you why. So I'm going over this because you've got kind of a two-part textual analysis here, which is look at the offer, which then incorporates the proposed release. I think we all agree indemnity is a non-monetary term.
correct.
All right, which right away should raise a red flag that, hey, is this outside the offer judgment such that we're doing a math comparison? Here's what you say: plaintiff department agrees that by accepting this proposed settlement, they are responsible for paying defense indemnity, blah, 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 with an insurable interest in the property that is the subject of this litigation as specifically stated in the release attached hereto as Exhibit A. You argue that the release is, you then read that in tandem with this to limit it to just the proceeds that the other person is receiving, which the third DCA held you could do, but the language in that actually said explicitly the proceeds that the other person is receiving. So you're going to indemnify if anybody explains these proceeds that I'm sending to the other person. Here, your incorporation of the exhibit actually as a matter of grammar only clarifies what the property that is the subject of the litigation is. In other words, you are, as I read this, plain and unambiguous, what you're saying is you, Blanche Hartman, are going to be responsible to indemnify for any claims against any and all lien holders, mortgagees, and any other person or entity with an insurable interest in the property, whatever that interest is, and the property that is described in the release attached as Exhibit A. And that's all the release does, is describe the property. Help me out with that.
Absolutely, Your Honor. So that provision specifically says, as set forth in the release attached here too, when we move on to the release and the indemnity provision of the release that further defines it, because the indemnity provision of the release specifically says any claim where a third party makes a claim.
So here's the thing, you didn't incorporate, you didn't actually say in the proposal for settlement, we hereby incorporate the terms of the release. Instead, what you did is you pointed to it and you say, as specifically stated, which as a matter of grammar, the way you got this set up in the sentence, would only apply to the last antecedent, which is the insurable interest in the property that is the subject of this litigation. In other words, Exhibit A, the way you got this structure is just describing what the property in the litigation is.
Your Honor, I submit that it could probably have been phrased better, but that sentence that specifically refers to the indemnity provision in the release, those two can go together. And I don't think that it's just the insurable interest. But even if it is just the insurable interest, that's all we're worried about right here. Because we're not talking about a lien holder, we're not talking about a mortgagee. The only argument that counsel has made is that we're talking about another person, Mr. or Miss, whichever one doesn't accept, with an insurable interest. And that's the one that under Your Honor's reading is tied to the release. And the release then says that third party has to come back and make a claim to the settlement proceeds. So here, the settlement proceeds, Mr. and Miss do not have a claim to each other's proceeds. The reason for that is that they are just that, settlement proceeds. It's not a property right, it's not an indemnity payment under the policy, and I think both parties' briefs are very, very clear on that. Because the indemnity under the policy, Tower Hill's position is that it's $0. And plaintiff's position, excuse me, appellant's position is it's about $120,000. So there's no correlation to the settlement amount offered there. The basis for the settlement offer is a sum of money that Tower Hill was willing to offer to resolve a lawsuit that it viewed as meritless. And it's allowed to do that. We've cited a number of cases in the brief that accept
Was
those.
there a negligence claim in that lawsuit?
In that particular lawsuit, no, Your Honor, there wasn't.
Was there an extra contractual claim in that lawsuit?
In that lawsuit, no, there wasn't, Your Honor.
So you're getting more out of the release than you would have gotten by just a straight cessation of the lawsuit, correct?
We are, but all of those claims are limited to those arising out of the same facts. And that is allowed under the case law that we have. And I know Your Honor brought up the Cush case during counsel's argument, and that specifically addresses that issue of what's extrinsic to the case and what it's not. In Cush, it was a first-party property case that did include a release of bad faith and punitive damages. And the court analyzed those two together. Now, the reason that analysis applies to bad faith cases as well is because the only way you can get punitive damages is with a bad faith case. And what the court found is that it was not an extrinsic claim because the release specifically said those punitive damages arise out of the facts of this claim. And that's what Tower Hill's release here says with respect to the bad faith, the extra contractual, and negligence. They all have to arise out of the claim at issue. So for that reason, we can have them all encompassing. That's also supported, Judge, by the Florida Supreme Court's Nichols decision, which again says the key to evaluating these proposals is to avoid ambiguity, not breadth. So here, it's crystal clear that appellants would give up their breach claims, their bad faith claims, extra contractual, if there is a difference, and anything else arising out of this claim. That is a broad release, but that's been accepted, and that's what the Florida Supreme Court's Nichols decision tells us we can do. One other point that I want to address is with respect to the good faith aspect. Here, and Your Honor's questioning was I believe, directly on point, because the good faith analysis only applies when we're talking about the amount offered unless there is reason to believe that there is nominal liability. And nominal liability, what we have to look at is from the defendant's standpoint, if the defendant has a reason to believe its liability is limited. And here, we have a claim that was reported, the adjuster for Tower Hill saw no visible damage to the property. The adjuster asked the appellants if there was damage to the property, and they responded no. And then Tower Hill's engineer went out, inspected the property, and saw no damage. From all of those factors, that's a pretty strong indication that there's no damage to trigger coverage under the policy. And as a matter of fact, that's exactly what the trial judge entered summary judgment on. So from that standpoint, Tower Hill had every reason to believe that it had no liability. And that is why this is considered a quote-unquote good faith offer, because it does satisfy that standard. And I think, Your Honors, what this case ultimately comes down to is the judicial philosophy that is going to be applied to proposals for settlement. And what I mean by that is on one hand, we can look at a proposal and try to find the tiniest inconsistency and use that as an excuse to invalidate the proposal. Essentially, that's what appellants are arguing for. On the other hand, we can start with a premise that a proposal that complies with the rule and complies with the statute is valid unless there's some uncertainty in there that affects the decision on whether or not to accept it.
Or we can take up Judge Gerber's suggestion in the concurrence and start requiring people to flag perceived ambiguities at the time that they receive the offer, or else to waive them.
Absolutely, and I think Judge Gerber made that statement twice, 10 years apart, if I remember correctly. But no such luck yet.
Pushed that line a couple times and got no bites yet.
No such luck yet. And what I'll submit, Judge, is that the philosophy applied by the Florida Supreme Court is the latter. It is to enforce these proposals for settlement. That's outlined in the Nichols case, and I'd submit that this court has recognized that and applied that. I know in the Carriall case, and Judge Valenti was on that panel, followed Nichols with that same philosophy. And in the Desidue case, Judge Lucas was on that panel as well, followed the same philosophy. That is what the court should do in this case as well. It gives effect to the statute, it encourages settlement, and it discourages meritless claims. That's everything the law should do. And for all those reasons, judges, we're asking the court to affirm. And unless the court has any further questions, we'll rest on our brief.
Thank you.
As to the first issue on the insurable interest in the indemnification, counsel has argued that it was only the homeowners. Well, we have a statute that defines insurable interest, 627.405. Insurable interest, that's in quotes, means actual, lawful, and substantial economic interest in the safety or preservation of the subject of the insurance. That could involve a lot of different people who have an insurable interest in it. There is a case where somebody had a car that they used, didn't know, they used it. That was an insurable interest. We don't know what it means. Bottom line is, the Supreme Court made it crystal clear in the 2022 amendments that they were bringing into alignment the rule with the statute, and now we should only be comparing monetary amounts. That's what the statute has always required. That's what it currently requires. The rule is in alignment with that. We're not doing that in this case. We haven't even tried to do it. And so, let me see if I think, Judge Lucas, you've made the point. They're getting more out of this release than they ever could have got in a judgment in this case. They just offered the judgment. That's accepted.
Well, your friend makes the point that, look, it's tethered to anything arising out of the lawsuit.
Yeah.
So it's not a blanket further release, it's just anything that could have been raised in this lawsuit but wasn't.
Yeah. It couldn't though. We couldn't bring it until we get a judgment of liability and damages. We can't bring the bad faith case till then.
Yeah, but that should stay. I mean, bad faith can be included in an offer judgment as part of a release, right?
No, I don't, it's extrinsic. I don't see how it's, I
I
hear you.
get
I
the
know.
2022 amendment
Yep.
swept away all the past case law without sub silentio.
That are in disagreement with what the statute is in monetary terms. But we could not, even if we abated it, they said we could have abated it. If there was an offer of judgment, that still wouldn't have addressed the bad faith if it was abated. And that's all I have. Thank you. Thank you.
Thank you. Thank you both. All right, the next case this morning is Smith versus the